Good afternoon, everybody. Thank you for joining us. I'm glad to be here today with my partner, Robyn Severs from Orlando. Hi, Robyn.
Hello.
So if you live in a condominium, a cooperative, or even a homeowner association in Florida, it may seem like your building's in a constant state of repair. I mean, between roofing, painting, concrete restoration, pool decks, pool remar siding, diamond brighting, asphalt, pavers, elevators, windows. You guys know as well as I do, the list goes on and on, the work goes on, and it seems like there's always something being done in the association. Especially with the new statutory structural integrity inspections and reports that are now required, the amount of work going on in your community will only increase. And while all of these repairs and maintenance are required and good for the building, choosing the right contractor to perform these jobs are critical in order to ensure that the job is done timely, properly, at a reasonable cost, and with proper warranties. So these are some of the things we're going to talk about today. How does an association find the contractor? As a matter of fact, in today's market, in today's economy, how do you find any contractor? What are the steps, the pitfalls? How do we get references? That's what we're going to hear today to discuss with you. So we're going to discuss the following topics: competitive bids and choosing contractors, vetting the contracts, licenses, insurance, avoiding common pitfalls, and these sort of things. So let's just dive right in. Hopefully we'll be out of here by 3 or 4 o'clock today, but we'll try to make it a little sooner. I'm just kidding. So Robyn, let's get started. What can you tell us about competitive bids and choosing contractors?
Thank you, Howard. So each of the statutes actually address competitive bid requirements. I did see that one of our attendees today that asked a question in advance is from a co-op, so I'm going to address the co-op as well. So in the condominium statute, any contracts that will exceed 5% of the total annual budget of the association, including reserves, require competitive bids. In the co-op statute, if the contract is going to exceed also 5%, including reserves, then you need to obtain competitive bids. In the HOA statute, it's slightly different, and that is if the contract exceeds 10% of the total annual budget, including reserves, then a competitive bid is required. Now, in all three statutes, there are exceptions for contracts for an attorney, architect, accountant, your community association manager, a timeshare management firm, engineering, and landscape architect services. You do not have to get competitive bids for those vendors. One of the other questions that we received ahead of time was about whether or not you need to get competitive bids each time that you are going to renew the contract. And I will let you know that in the HOA statute, this is not in the condominium statute. I'm sorry. Yeah, it's not in the condominium statute. It's in the co-op statute for some reason. So in the co-op statute and in the HOA statute, if you are renewing a contract and that contract initially went out for competitive bids, you don't have to go out for competitive bids again, as long as the contract provides that the board can cancel it for any reason upon 30 days notice. So those are the statutory requirements for condos, HOAs, and co-ops for competitive bidding. You also need to look at the governing documents of all of the associations because they may have increased bidding requirements. I know that there are some that actually require a specific amount of bids. So you will need to also follow your governing documents. Now,
Robyn,
the stats. Oh, go ahead.
I'm sorry. Let me ask you a question, Robyn. What do we mean by competitive bids? What does the statute mean by competitive bids?
The statute doesn't define what competitive bids are. It also doesn't state how many bids that you need. So basically, you simply need to get 2. Now, for good practices, especially if you're doing a major reconstruction project or installing a pool, the standard is you're going to want to get 3 bids because that just makes sense. But the law only requires you to actually get 2 bids in order to meet the statutory requirements. And I think that's a really good question, Howard, because I get that question a lot from my clients. They're like, oh, I can't get a 3rd bid. And I'm like, that's okay. You got 2. You're good. If you've tried to get a 3rd bid and you can't, then you can go forward with your 2 bids. In order to find vendors out there, then basically there's a variety of places you can go. You can talk to your neighboring HOA, your neighboring condo, your manager, your attorney, other vendors that you use, your accountant. If you have an engineer already that you're working with, I mean, there's a variety of places that you can get referrals for the vendors that you want to use. The other thing that I want to mention regarding competitive bids is that for a lot of these big projects, you are actually going to want to hire an engineer to prepare a scope of work for your project. So basically prepare a request for proposal, a request for bid for the project. That way, when the bids come in, you're actually able to compare apples to apples. I have an association recently that got bids, and they're all different. And so they're like, we're having a hard time comparing them because they're completely different. And so we don't know which one to go with. So that's why it's helpful for you to have an engineer prepare a proposal, and then you send that out, and then the contractor has to provide the information that's in your request for a bid or a request for a proposal. I will tell you that when you're reviewing the bids, don't necessarily take the lowest bid. That's not the only factor to consider. You want to consider the reputation of that particular contractor. You want to determine how long it's going to take for that contractor to begin. How long is it going to take to complete? There's a variety of things, whether or not there's going to be on-site supervision, like is the general contractor just going to visit, one day and then not ever again? There's a lot of things to take into consideration. There's no requirement for you to take the lowest bid. So you do need to look at the whole picture when you're trying to look at these contractors. And then when you actually get the bid and the contract back from the contractor, Howard, how does an association actually vet the contracts that they're receiving?
Well, obviously, there's a lot of ways to do that. And like you said, major work like roof replacement, painting and waterproofing, concrete restoration, a lot of things that are coming up now, and a lot of things that'll be part of the structural integrity work that's going to have to be done in the upcoming years. You do want to have a formal bid package prepared by the association's engineer working with the association. And this bid package is going to be very comprehensive. It'll provide detailed specifications that each bidder is required to comply with. So we can get, like you had mentioned, the apples to apples bid comparison that every association wants to see. How do you engage an engineer? I think Robyn just discussed that. So you engage an engineer the same way you engage any other contractors. The formal bid package is going to have a lot of information in it. And depending on the job, this can be 10 pages, it can be 40 pages or more. It just really depends on the job. It's going to have the specifications for the work, the timetables, payment provisions, payment approval provisions. How do payment submittals get approved? Who approves them? Insurance requirements, and we're going to talk about more about insurance later. Warranty information. We're going to talk about more about that later. Performance deadlines. Penalties for missing these performance deadlines, inspection requirements, who pays for permits, bonds, are we going to have bonds, and a lot of other, and that's just, the touching the surface. There's a lot of other information that are contained in these big packages. And generally the engineer will also include a matrix with that bid package where each one of these items that I just mentioned is listed. and the contractor can put in his or her particular cost for that particular item. And that way the association can compare apples to apples. And what you'll see in those matrices sometimes is maybe there's a cost for painting the exterior and you put your cost $1,000. And then there's a cost for, window caulking, $500. Now, somebody may put $1,000 and $500 separate. Another contractor may come in and it'll have painting and it'll say $1,500 or $2,000, and they'll have nothing under window caulking. Okay, that doesn't necessarily mean they're not going to do the window caulking, but you have to go back and ask those questions. And the contractors are going to come back and say, oh yeah, our painting cost includes the window caulking. And then you're going to want to go back and say, we need you to break that out. That's the purpose of that matrix, because a lot of time contractors like to roll everything together, and it doesn't really give the association an opportunity to really compare all these different items. So that's the purpose of that matrix, is that once it's prepared by the engineer with all the contractors having their information, you may have to go back to some of the contractors for verification. Hey, you didn't put this. Hey, you forgot about that. And the contractor is going to say, we're not going to do that. It's included here. So that matrix is sort of a living document that the association can use to go back and forth with the contractors while you're vetting them and while you're vetting these contracts to make sure you get that apples to apples comparison. All right, so that matrix can be very, very important.
Howard, I'm sorry, I just have a question for you. I've had a couple of times where the association has said, well, the person that submitted the bid didn't follow the instructions in the request for bid or request for proposal. So, is that something the association should consider when they're vetting their contractors, do you think?
Well, obviously, it's something you want to consider, and how the association reacts, I think, is going to depend on what type of contract we're talking about and how many bids you have. Yeah, for example, if you're doing a major concrete restoration, millions of dollars, you may have 7 or 8 bids. I mean, it's not uncommon to get 7 or 8 bids for those types of jobs. And if you get 7 or 8 bids, and one person or 2 people don't comply with or don't follow the instructions, but the other 6 do, my opinion, shame on them. All right. And there's nothing wrong with saying they're out of the bidding. They didn't comply. They didn't submit the information. Nope, your problem, not ours. If the association wants to go back to those contractors and say, hey, here's what you asked you to do. You didn't do that. Please resubmit. There's nothing wrong with that. Now, conversely, if you only got 2 or 3 bids and 1 or 2 of them didn't comply, then obviously you're going to want to go back and ask those contractors to, toe the line and get their proposals in with what the association requested. And most of them are willing to do so. Again, in today's market, between COVID and the supply chain and everything else these days, a lot of things aren't like they used to be. But at the same time, I urge the associations, don't let contractors use that as an excuse for not doing what they're supposed to do, and don't use that as an excuse to lower your standards or requirements. And I think that's one of the biggest pieces of advice I can give today. Don't let the contractor say, because of this, because of that, I can't do that. Anybody can provide a bid. Anybody can fill in the blanks. Anybody can provide a matrix. Anybody can provide licenses. Anybody can provide insurance. And if your contractors are trying to make up excuses why they can't do that, that needs to be taken into consideration considerably, in my opinion. So a couple other things about the bid package. So like I said, those matrices and everything, obviously those are for large jobs. I'm not saying you need a matrix or an engineer specification package for a $5,000 pool heater replacement or a $15,000 playground installation. You can if you want, there's nothing wrong with it, but obviously you're not going to need that much detailed information in regard to those bids. but you're still going to want to check the references. You're still going to want to verify licenses and insurance. You're still going to want to look at warranties, regardless of whether we're talking about a $5 million concrete restoration job or a $5,000 pool heater replacement. Those basics are things that we always want to do. And Robyn, before I ask you to discuss some information about licenses and insurance, what can you tell us about bonds? And in particular, the difference between performance bonds and payment bonds?
So bonds are basically one of the many ways that you can protect your association. So a performance bond is a bond, it's like a surety bond that you enter into. You actually ask the contractor or vendor to provide the performance bond, and they will reach out to surety companies who can provide that performance bond. The performance bond is to guarantee completion of the work. So basically, you know, if your contractor starts doing your balcony reconstruction project and for one reason or another is not able to complete it, then the surety, you know, you can make a claim on the surety, and either the surety will hire someone to complete the construction, or the surety will pay you in order to be able to have the funds in order to complete the construction. You do need to seek legal advice on these performance bonds. Have your attorney, as part of the review of your contract, to also review the performance bonds, because they can contain different scopes on basically whether or not you would be able to obtain additional damages. Like, you know, if your property is further damaged due to the lack of work of the contractor, those sometimes are in there, sometimes not. Also, you need to know, are there procedures that you need to follow in order to make a claim on that performance bond? Sometimes you have to provide proof. Sometimes the surety will have to come out and investigate it. So you do need to have an attorney review of those performance bonds as well. Now, the payment bond also protects the association, but in a different manner. Again, the contractor will be can be required to get the payment bond. And this, you know, kind of sounds exactly like it sounds. It ensures that payments will be made to the person or for the supplies that the contractor hires. So the contractor, the subcontractor, the material man, you know, any laborers, because the association is accountable to those subcontractors and insurers. And these subcontractors, material men, and laborers can also make claims and file liens against the association if they don't get paid. So if the contractor doesn't pay the person beneath them, then there's a bond in place to make sure that those payments are made. I will tell you that payment bonds are covered by the statute. It's 713.23 if you want to take a look at it. And also, when a bond is in place, you have to record the bond. When you record the notice of commencement, to let everyone know that there is a bond. And when the bond is in place, the owner is exempt from certain provisions of the construction lien law. So I just, you know, it is kind of helpful in these big projects to get this payment bond as well.
Robyn, who pays for these bonds? Who pays for the bonds?
So part of the contract would be that the contractor would pay, you know, would pay for the bond. And it's a certain percentage based upon the amount of the bond. And you can actually put in your contract or in your bid package that you're going to require a certain amount of performance bond or a certain amount of payment bond or both. And then, you know, in response to the bid package, the contractor can say, yes, I will do that, or no, we're not interested in that.
Yeah, and I guess the contractor can tell us how much that they're going to charge for because, you know, I mean, if we make them pay for it, obviously they're going to charge the association, so they can let us know how much.
They'll loop it in. Yeah, they'll loop it in. Yeah.
It'll be, well, I think it should be part of the matrix so we know what it is.
Mm-hmm.
And I will tell you, you know, honestly, I haven't done any maybe for 3 or 4 months, but as of 3 or 4 months ago, I would say the going rate for these bonds was about 1.5% to 2% of the contract price. So just something to keep in mind when associations are doing their budget calculations for whatever project they're considering. You know, if you're considering a $5 million contract, you know, 2% is a significant amount. if that's what you're going to end up paying at the end of the day for a bond. So just something for associations to keep in mind.
And as with everything, you have to determine the risk and the benefit. What is the type of project that you're undertaking? Is it worth the extra amount of money to have the peace of mind that the subs will be paid or that the work will be completed?
Right, exactly. And we talked a little bit earlier, we mentioned, I should say briefly, licenses and insurance. And I'm sure you get the questions all the time, and I get the questions all the time. Do we really need to check licenses and insurance? Come on.
Yes, you do need to check licenses, insurance. I mean, you have to remember that, someone who has gone through the effort of obtaining a license, there's background checks that the licensing authority typically have to do. There's procedures. I mean, there's some type of vetting process that you have to go through, as well as an educational process in order to get the license in the first place. And so it is important to have someone who is properly licensed. Also, there are state statutes that govern the validity of work and contracts by unlicensed personnel. And actually, it states that if you enter into a contract with an unlicensed professional and someone who needs to have a license to perform the work, then that contract is void. Now, that doesn't mean that the contractor couldn't sue you for other reasons, but that just says that the contract that may have delineated terms will no longer be enforceable. But that doesn't mean that the other people that also perform work, again, these subcontractors or the people that provide materials, they could still come after the association for the work that they're performed. So it is important to make sure that you have valid licenses. And you can check, first of all, your contract can require, should require that they have a license and to provide you with the license number and what type of license it is. You can also go on the Florida website. It's myfloridalicense.com, where you can actually search and verify for the licenses. You can also go to your local government and make a ask the local government whether or not they have a license, because you want to make sure they also have the license to work in the county in which they are working, not only the license like the general contractor license, but the license to perform work in that particular county. And you can require that again, I think I said this in the contract, the license number should be provided to you. So you're able to either look it up either by the license number or by the name. And in some situations also, you have to remember that there is, like for CAM, the actual CAM has to have a license, but the company itself has to have a separate license. So you may need to be looking at more than one license when you're doing that license check.
Yeah, and I'll tell you, one of the first things, I'm sure you do the same thing, whether any contract, the $5,000 pool heater replacement, or the first thing, first of all, and I think we mentioned this, maybe we didn't, but generally, you're going to want your association attorney to review all contracts. And I say all contracts, and yes, to me, that includes the $5,000 pool heater contract. And I'll tell you why. As attorneys, one of the first things we look at is, one, is a corporation valid? If it's ABC Pool Heater Company, well, the first thing we do is we go and we look is there an ABC Pool Heater Company? And you'd be surprised, occasionally there isn't. So you're going to check that. And then, as you say, in regard to licenses, we check their licenses as well. So this is one of the reasons you want to have this stuff go through your attorney. And the other thing, when you're looking this stuff up, you can see if there have been any complaints filed against that corporation or the contractor. And again, I've run across that several times. The association has a wonderful interview with a certain contractor, and they're ready to hire this guy, and they send you over the contract for review, and we check those first couple of things, and I got to go back to the association and say, hey, did you know that Bob, the licensee or person who holds a license, has 3 pending violations, or that he was suspended for 6 months for XYZ? And sometimes the associations are astounded. So even for that $5,000 pool heater, I don't think an association wants an unlicensed contractor or somebody who has had their license suspended or somebody who doesn't have proper insurance, doing that kind of
Mhm.
work. So this is why you want to send these contracts to the association attorney for review. And I'm going to ask you, I'm sure you're going to, I know the answer you're going to give me. How many times have you had an association send you a contract for review and you go through it, and by the time you get to the bottom, the association has already signed it?
Too many times. And that's important because the way the law is that a contract is enforceable against the party who has signed it. So if you have a contract that you've already signed, the contractor can enforce that contract against you, even though they haven't signed it. Now, of course, there's offenses, but I mean, if you've signed it, you've basically agreed to the terms. So then you're already saying, I've agreed to these terms, and if you try and go back and change it, they might say, why should we change it? You've already signed it.
We had a couple questions submitted in advance regarding contracts. So let's go over a couple of those now. We'll bounce them off each other. So John asked a question, can just a board member approve a contract?
Generally, no. Basically, the board is supposed to make decisions on all issues. So all contracts should come before a board at a properly noticed and open board meeting for all the board members to consider and for the board members to be able to vote on it. Now, I have had situations where the board members review the contract, vote on the contract, and then they might delegate the authority to the president to sign the contract or to sign any necessary documents in order to complete the project, like the notice of commencement or something like that. But the contract itself has to be reviewed and approved by the board. Just another piggyback on that, because I think I remember also seeing about, does the board have to interview the contractors? And I do know that some associations like to set up a committee, appoint a committee to do some of the initial legwork, to investigate and review some of the bids. And then the committee might make a recommendation to the board. But again, it still comes to the board for approval.
And you mentioned committees, and I think that's important because sometimes associations, the boards can inadvertently and very innocently get in trouble interviewing contractors. Because if you have a contractor that's coming to the association, to walk the building and look at the job, and you have a 5-member board and 3 board members are meeting with that contractor, that's technically a board meeting. It's technically a board meeting that's supposed to be noticed with a 48-hour notice with the owners available to attend and participate on agenda items. So I don't think, a board wants 3 board members and 17 interested homeowners following the contractor around, while they're showing them the scope of the work. So board members, and managers, be aware that even though it's just a question of, we're meeting with the contractor to go over the job, you don't want to do that with a quorum of the board because, again, you can run afoul of some of the requirements of the meeting requirements. So that's why Robyn said appoint a committee. Even if you have, a committee of 2 board members and 3 owners, it's still less than a quorum, and that way you can get around that. I have, especially with all of the jobs that are going on now, I have a number of associations that are fighting with owners who want to participate when the contractors are there walking the building. And the bottom line answer is no. Okay, that's not a homeowner, that's not a unit owner function, that is a board member function. So you don't have to allow that. And other than outside of the committee, I would not allow owners to do that. And that's going to be coming up more and more, I think, especially as the owners are getting assessed with all of these charges. They're going to have to pay for all this stuff. They rightfully want to know, what's going on. Another question we got from, well, this is a question that I think was philosophical, but maybe not, because you and I talked about this earlier. Is an increase of 700% from the original bid unusual? My answer is yes, that's unusual. I would have, 6 months ago, I would have said outrageous. Now I'll just say unusual. But no, an increase of 700% from an original bid, something's wrong. It sounds to me like somebody accepted the lowest bid. And then when that person went out to actually price out the materials, it was an issue. But yeah, a 700% increase is a lot. And the other question went on to ask, what kind of documentation should the contractor to provide to support such an increase? Well, I would hope that whatever contract was signed would not allow for a unilateral 700% increase. And I guess that's the best way that I can answer that. And I want to piggyback on the answer you just gave about meeting vendors, because one of the follow-up questions that we got is meeting vendors the board's responsibility? My fellow board members don't think so. They think the management company is the only one that should meet, and the management company should handle all of that. So what are your thoughts on that?
Well, I think the management company is a good resource, but again, the management company is not responsible for operating or maintaining and repairing and replacing your common areas and your common elements. That's the association responsibility, and it's the board responsibility to make those decisions. And I think part of the vetting process is for the board to be able to interview these contractors to make a determination as to whether or not that contractor is the right fit. So many times people look good on paper, or the bid looks good, and then you actually meet them, and they're completely opposite than what the paper that they provide. So I think that in-person interview credibility determination is important for directors to do that. I think the directors need to be involved in the process. Again, I think the manager is a good resource to rely upon for experience and provide their practical opinions and their professional experience opinions, but ultimately it has to be a board decision, in my opinion. I don't know if you feel different, Howard, but.
No, I agree. And I think, what I always recommend to my associations, again, for these large jobs, painting, waterproofing, concrete restoration, pool remodeling, any of these large jobs, you should have a board meeting where all of these 2, 3, 4, 7, 8 vendors, however many, come and make their presentation to the board in front of the owners. And the board's members ask questions and the owners ask questions. And this does a lot for an association. One, it gives that transparency. It gives the board that transparency. With all of these millions of dollars of contracts being bandied around, you always have owners who they heard the horror story. And if you live in Miami, there's a lot more horror stories than if you live anywhere else. Sorry, Miami, just a fact. But are we taking kickbacks? Who's doing this? Who's doing that? These questions always come up. And if you have this open meeting where the contractors come and the owners are allowed to ask questions and get the answers from the contractors, not from the board, that can go a long way to peaceful community relations and letting the owners feeling like they're involved. And so that's the way I recommend, that those type of interviews be done. One thing we didn't talk about, a question, Madeline asked a question, and I had to answer Madeline's question because Madeline's my wife's name, but this isn't my wife's question. It's just her name. Okay. She says, I would like to know more about the final release we should obtain from the contractor prior to final payment, such as what should be included on the final release. And this is a great question because we just peripherally touched on notice of commencements and progress payments. And, we could sit here for 3 or 4 hours and really get into all the nitty gritty if we wanted to, as far as progress payments and retainage and releases of liens and all of that stuff. And for everybody on the webinar, unfortunately, we're not going to be able to get into all of that detail today, but this is why it's so important. Run these contracts by your attorney, because part of the contract that the attorney is going to send back, if it's not already in the contract from the contractor, addresses all of these issues. Partial payments, releases of lien. What does the association get before it gives the contractor a check? The association on these larger contracts is never going to generally just give a check, even though the work has been approved. You're going to want a partial release of lien. It's a mutual thing.
Mm-hmm.
So what can you tell us more about the final release in those types of situations?
So the final release basically is where the before you get the final payment, or usually it's happened at the same time because the contractor doesn't want to provide you the final release until they get the final payment. But the final release basically is a representation by the contractor that it has paid all of its subcontractors or laborers, and that so there's not going to be any liens filed by those individuals. And it also means that there is not going to be any lien filed by the contractor itself. And there are forms for the partial releases as well as the final release in Chapter 713. Not only would one of the attorneys review that language in your contract, but when it is time for you to receive that lien release, then you either should have your attorney prepare it or review the one that's being provided by the contractor. So it is very important that you get that final release of lien. But of course, you don't want to provide that until you've, and again, this should be in a contract, that you have inspected the property and that all of the items that have your concerns, if you have concerns about certain portions, all those, I can't think of the word that I'm looking for right now. The punch list, yes. The punch list, everything has been met and you've signed off on it. Because you don't want to pay the contractor until you are satisfied with the work that has been performed.
Right. So very good, great question, and a very important part of this whole process. A little bit to the side here, Martha asked a question. What do you do if you have association members who are willing and capable of doing small jobs for the association? Can you let them? Can you pay them? I'll give you my opinion, and then I'll, see if you agree with me or not, Robyn. My general answer is no. Association members should not be doing work for the association, period, end of discussion. I know, well, we just want to plant some flowers at the entrance, or we want to do this, or we want to do that. And from my opinion, there's just too much liability involved for the association. If that person gets hurt, God forbid, if they hurt somebody, there's no reason for it. If it's a small job, the association can pay a licensed person to do the small job. So that's my opinion. I don't know if you feel any differently.
No, I agree with you, Howard. I have had some associations that have pushed back on me about that issue. And while my opinion is the same as yours, I have in those instances had those volunteers basically sign, waivers of releases and indemnifications. We could have a whole nother conversation, a whole nother seminar about waivers and indemnifications and whether or not they would hold up in court. But, so the first answer is no, I do not recommend it. But to the extent that, you really want to have it, then at least, again, consult with your attorney to make sure that they are putting what documents they can put in place to try and further protect you or insulate you from liability.
I agree. I'm just going to pick a couple of the Q&As that have been going on here. Don asked, would you please repeat the exceptions to competitive bidding? So the exceptions to the statutory requirements that Robyn mentioned to competitive biddings are the attorney, the accountant, architect, the community association manager, engineer, landscape architect, and I think there was one other one you mentioned.
Timeshare management firm.
Thank you.
That's for condos, obviously.
Mm-hmm. So, and again, you can find those in the statute. Another question, and this one happens unfortunately more than we would like. What is the best way to handle when the contractor wants to know what is the best price to get the bid? And my answer is your best bid. That's the best price to get the bid. And when a contractor asks you that, that's a red flag to me.
Yes.
That's a big red flag. Understanding that, you know, a lot of times associations have long-term relationships with a lot of vendors, you know, that have been doing the work for a long time. And the vendor may innocently ask, what is the best price to get the bid? You know, in that case, you're just going to say, look, just sharpen your pencil real sharp and give us your best bid. It's my experience, those type of questions come more often from the person who just wants to know what they need to bid to get the job, as opposed to what, you know, what they really want to know. So that's the way I would answer that. I don't know if you feel differently or not.
No, I agree. It's a red flag. And my concern with that is whether or not they're going to underbid. And then when it comes to actually presenting you with the contract, it's going to, you know, have the original, basically maybe they're underbid, but then they're going to have like, oh, but you have to have an addendum for this, this, and this, and this. And so then you've accepted a bid, which really wasn't the true bid. So that would be a concern that it would change.
All right, I'll ask you this question. Carolyn had a question. Should your management company be signing contracts?
No. No.
Great
No,
answer.
end of story. No, the managers should not be signing contracts. Again, you have to remember, first of all, these are contracts with the association, and then the association is going to be held liable. I have some associations where their governing documents actually require that the contracts are signed by 2 officers or 2 directors. So, you know, look at your documents, but even if that requirement is not in your documents, you need to have, typically it's the president, sign on behalf of the association.
I agree 125%.
Yeah.
We talked a little bit about insurance briefly, but one of the questions that always comes up, it seems to be, is workers' comp insurance. And 2 questions come up. One, you know, do all the contractors need workers' comp insurance? What if they say they're exempt, you know, based on the statute? And 2, does the association need workers' comp insurance?
So we do have an employment attorney on staff that I would probably ask for assistance with this. There are exemptions to the workers' compensation. Again, this is another reason why you rely on your advice of counsel. But generally, the contractor should have workers' compensation for the people that work for them. And to the extent that they claim that they're exempt for one reason or another, that's the reason to ask your attorney whether or not they are truly exempt.
Yeah.
But yeah, that's one of the, I mean, again, the purpose of the insurance and the purpose of having the association as an additional insured on the contractor's insurance policy, and also to make sure that the contractor provides a copy of the insurance. There are certain types of insurance you need, you know, workers' comp. Sometimes you're going to need some type of car insurance. If there's going to be some type of traveling, you might want the car insurance. Obviously, you want liability insurance. And, you know, you should reach out to your insurance agent. Again, you know, the attorneys can give you some type of guidance, but you have your insurance agent who is your expert to rely upon as to what insurance would best protect the association. So it is very important for you to have insurance in those contracts, whether it's workers' compensation or anything else, in limits that will provide protection to the association based upon the scope of work that's being performed.
I want to follow up on 2 things you mentioned, the term additional insured. So it's important, again, on these large contracts, that the association be named as an additional insured on the contractor's policy, not just a certificate holder. So again, that's something your attorney is going to check on, but, you know, just be aware the association wants to be named an additional insured, not just a certificate holder. That gives the association much more rights as an additional insured. So I think that's one of the other things we want to mention. All right, let's talk about some of the pitfalls. All right, so what are some of the pitfalls that an association can sort of try to be aware of and try to prevent? And I mentioned this one earlier, but one of the most important pieces of advice I can give is do not sign the contract before it's been reviewed by your association counsel. These large contracts, a lot of the contractors will use what's called an AIA contract. It's a very standard form of contract that are made for all different types of professions. And these contracts were not written to protect the association. These contractors were written for the contractors. So AIA contracts, generally this firm doesn't use. If somebody submits an AIA contract, generally, our construction attorneys will write a new contract, maybe referring to the AIA as an exhibit for some of the specifications. So don't sign it before the attorney looks at it. These one-page contracts that we get, one page, it's actually a one-page proposal, the signature line, you turn it over, and there's a whole page of type in a font 4 that I can't even read with a magnifying glass. To me, those are red flags and not something you're going to want to sign. And again, if you look at that small language, it's in the favor of the contractor, not the association. Now, we may be able to just prepare an addendum to that type of a thing as opposed to preparing a whole new formal contract. But again, don't sign these without your association attorney looking at them. Same thing with notices of intent. All right, some contractors want you to sign a notice of intent. Oh, it just means you're going to sign a contract with us. The attorney can review the contract, just sign the notice of intent. Do not sign a notice of intent before the association has looked at it. In many cases, the notice of intent can bind the association to the contract just like the contract. All right, so you can be aligning yourself or engaging yourself to that contractor before you even sign a contract by signing a notice of intent. Here it is, we're the middle of June, end of June, we're already in hurricane season, right? Florida, we have 6 months of hurricane season. We all know what happens when a hurricane hits South Florida, right? All the contractors from all over the country come down to Florida looking for work. And, a lot of times we need them. I mean, we don't have enough contractors down here now. And after a hurricane, you need a lot of these out of state or out of town contractors. And many of them are legitimate companies. Unfortunately, many of them are not. So one of the biggest pitfalls I see, and a big piece of advice in regard to dealing with contractors after a catastrophe, any catastrophe, whether it's a hurricane, a fire, a flood, do not lower your standards. Just because contractors may be hard to find, just because you need a contractor now, don't lower your standards. You still need to go through the vetting process. You still need to check references. You still need to check licenses. You still need to check insurance. It's more important after a catastrophe than under normal circumstances because you have all of these companies trying to take advantage of you. All right. And it's unfortunately, they're just out there. Legitimate companies that operate outside of Florida that then come into Florida after a catastrophe, they have licenses in Florida. They have insurance in place that'll cover you in Florida. They have all of this stuff in place before the catastrophe occurs. So that way, if you do your vetting process, these legitimate companies will vet out. And it's the illegitimate companies that won't vet out. And, it's just like buying a car, unfortunately, some of the really red flags. You need to sign the contract today. I can only give you 25% off today. We need 50% down. So if you sign the contract, I got the guys in the truck, we can get to work right now. All right. These are all red flags. And while the manager and the board, you're under pressure, your community is in a mess, you may say, great, you can start right now. Great. Give me the don't do it. Take your time, vet the thing. Another thing you want to really watch out for, and some of these are legitimate, you just got to be careful, is that where they say, just sign the contract and all the payments will come from your insurance company. You won't have to pay anything. Well, until your insurance company says that's the case, that ain't necessarily the case. All right. So don't fall for that trick. Bottom line is any type of pressure tactic is a red flag. any type of pressure tactic is a red flag. The companies that are down here to do good work, that want to assist you, they're not going to pressure you. They're going to give you their options. They're going to say, we're here to help. You want to use us, great. If not, they got 35 other associations right down the street they can go work. So, you know, it's easy to fall into that trap, but don't do it. As they say, there are no free lunches, even though the contractor may want to take you out to lunch, and that would be a free lunch. You understand what I'm saying? So those are some of the big pitfalls. Is there any other ones you can think of, Robyn, that I maybe didn't mention?
No, I agree with all those. One of the other things that you might want to look for in your contract, again, this is why you have an attorney review it. But a couple of things I wanted to piggyback on when you were talking about the contracts or these invoices, these one-pagers that you get. I don't know how many times where I've had an association come to me and say, well, this contractor didn't complete the work, or we're still waiting on the contractor to do the work, or the contractor hasn't even started the work. And I said, well, can you send me a copy of the contract? Oh, we don't have a contract. We just have this proposal. Well, that proposal can still bind you, just like a contract. I mean, it may be a poorly drafted contract, but that is still an agreement basically between you and the contractor. And so that will still bind you. And if it doesn't have, start dates, completion dates, that's one thing right now with labor and material being an issue. I've seen some contracts, unfortunately, they were not vetted by an association that didn't have a start date, didn't have a completion date. So when it's a year or two later and the work still hasn't been performed and they come to me, I'm like, well, there's nothing in there about the start date and completion date. I mean, it's not that you won't have a case, but we're going to have a harder time showing that there's a breach. Yeah.
Yeah, no, those are good points. And again, not to beat a dead horse, but that's why I can't explain how important it is to have the attorneys look at these contracts beforehand. And here's a perfect example, a question from Anna. How do you hold contractors accountable to honor their warranties? All right. And if the contract was written properly and you have your warranty provisions in there, you enforce it like you enforce any other term of the contract. There's probably going to be a notification requirement. There's probably going to be an inspection, option where they can come out and inspect. They're going to have an opportunity to cure. That'll all be spelled out in the warranty. And then if they don't comply with the terms of that warranty, if you have to file a lawsuit to enforce, unfortunately, that's what you have to do. But, the beginning step of that is to have that warranty information in the contract. Without the warranty information in the contract, you're dead in the water. So that's how I would answer that question. Here's a great question we get all the time, Rob, and I'll throw this one out to you. Do you have to have closed bids, and do the bids have to be opened in front of the membership?
So you do not have to have closed bids.
You're kidding.
The bids are part of the official records of the association. And if you are a condominium that is required to have a website, then those bids, and you might have to remind me of the time, is it 1 year that they have to be placed on the website?
Yeah, it is.
It's
just a listing of them has to be placed on the website.
Okay. So yeah, and actually that segues to something else, because I hear this all the time about, well, we need to keep these confidential. There's few things that are confidential in the condominium context. So I understand that there may be concerns from these contractors regarding the confidentiality of their bids. But if they're dealing with HOAs, condos, and co-ops, they should know that those bids are part of the official records. And if an owner makes a request, they can receive a copy of it.
Sure.
So, yeah.
And I know a lot of times, again, the last couple of years, all this concrete restoration, unfortunately, you know, the tragedy we've had down here in South Florida recently, the new structural integrity reserve inspections that are going to be required, you know, and the owners say, hey, we want to know what's going on. We want to know who's going to be paid our millions of dollars. We want to be able to see these bids. We want to be able to see, you know, what the bids are coming in. And I think they certainly have a right to do so. It's their money. Okay. So while, you know, like Robyn said, it's not required to have sealed bids, but there's nothing wrong with having all the bids opened at a board meeting, just for, again, for transparency purposes. So the board can say, okay, we got a bid from ABC Concrete and the total amount is 10 million. And we got a bid from XYZ Concrete and the total amount is 5 million. And just go through who they got the bids from, the total amount. Because remember, once you open those bids at that meeting, nobody's going to be able to discuss them at that meeting. Nobody's looked at them yet. Okay. So the purpose is the transparency. Once they're opened, at least the owners can say, okay, we got 6 bids. Here's the name of the contractors. Here's how much each one bid. We haven't put them into the matrix yet. We don't know if they're apple to apples. We got to go through them, but at least that can, you know, put a salve, if you will, on a lot of owners' concerns about what's going on, who's opening the bids. You know, are we telling this contractor the bid? Are we giving the prices? So again, depending on your community, look, some communities, questions like that never come up. It's not an issue. And those are nice. Other communities, you know, the board is under a microscope, whether rightly or wrongly. So by doing some of these little things, by opening these up in front of everybody, again, transparency can go a long way, you know, in resolving some of these issues. So I think that's important. I got a question here from Darlene. We only got a few minutes. Robyn just mentioned if a condominium complex is required to have a website. How do we know if our condominium complex is required to have a website? Robyn?
If you have 150 or more units, you are required to have a website.
Yes, and not only are you required to have a website, there is a whole laundry list of information that is required to be on that website. So if you are an association of 150 units or more, and I honestly, I don't remember if it's 150 units or more than 150 units. So
Yeah.
please, I don't want the 1 or 2 emails I'm going to get that I gave the wrong information. It's in the statute. But again, more importantly is the laundry list of, you know, what information has to be there. So that's very important. I'm dealing with a Department of Business and Professional Regulation complaint right now about information not being on the website. Another question from an anonymous attendee. And when you hear the question, maybe you'll know why. The president of my board does not want to sign a painting contract after the board approved it and after the attorney's review. Who else can sign it? I think the board can delegate anybody, any officer to sign that contract. So,
yeah, typically the vice president is the next in line, but to the extent that the vice president is unwilling or unable to do so, then yes, an officer.
All right, Robyn, it looks like we've almost used up our time. Do you have any parting thoughts before we go?
No, I think we've, you know, told them enough times how important an attorney review is. But you know, this is going to be a big issue going forward because of the labors and materials, because of the new condominium requirements for structural inspections and reserves. So, you know, I can't stress more than what Howard already said. You know, don't rush through this process. Be careful, do your review, do your vetting, and make sure that you are doing what's best for your association.
And I just want to say, first of all, thank you all for attending. Robyn and I both thank you, and we hope you found this informative. I'm sorry we didn't get to all your questions. There were a lot of them. We got to as many as we could. And, you know, you can always reach out to your association attorney. And I encourage you to reach out to your association attorney with whatever particular questions you may have. Everybody have a great, safe July 4th weekend. See y'all later. Thank you, Robyn.
Thank you, everyone. Thank you.
Bye-bye.